North Carolina is playing a starring role today in a Supreme Court case that could decide the future of partisan gerrymandering once and for all. To understand the importance of this case, let's first get you caught up on how we got here. Take a look at the timeline. Earlier this year, the General Assembly drew congressional maps. Someone sued in the state Supreme Court saying they were too partisan. Then the Supreme Court decided they agreed with the person suing, drew their own maps, which were used for the election because there wasn't enough time for the General Assembly to try again. And that is what House Speaker Tim Moore appealed to the Supreme Court. He said, that's not right. The Constitution gives that power only to the legislative branch, not the state Supreme Court.
States lack the authority to restrict the legislature's substantive discretion when performing this federal function. As Alexander Hamilton wrote in Federalist 78, the scope of legislative authority is governed by the commission under which it is exercised. Here, that commission is contained in the United States Constitution.
Counsel for a group backing the North Carolina State Supreme Court warned justices on the High Court Wednesday that the implications of this election case would be drastic.
The blast radius from their theory would sow elections chaos, forcing a confusing two-track system with one set of rules for federal elections and another for state ones. Case after case would wind up in this court with a political party on either side.
This is one of two big North Carolina cases currently being decided by the Supreme Court. The other one is centered around UNC's affirmative action emissions policy.